My lords, the counsel for the appellants could not find the VC link right now, so he'll just pass over for some time. He's appearing from Guwahati.
Item number 2.
Lordship, seems now the notice has been completed and my learned friend is appearing. So it may be fixed for hearing, my lord, next week or any other day.
Your Worship, it's quite a simple matter. Only one point is involved. Whether the competent authority can review his award, which was already declared. So if my learned friend is not ready today, then sometime next week. Only one point is involved.
Authority cannot review. Once the award is passed, then as regards the quantum of compensation, it has to be decided by the arbitrator.
Arbitrate.
You can very well challenge before the arbitrator. Why you are before anybody else?
My lord, there is some misconception regarding that, my lord. Now, the issue involved herein is that my learned, the respondent, my lord, are not happy with the award. And in that case, my lord, there is a specific statutory provision saying that anyone who is not happy, who cannot accept the award, will have to approach the arbitrator.
No quarrel. 3G5.
3G5. So instead of approaching that arbitrator, they straight away come before your lordship. So they have not, my lord, availed all those statutory remedies, my lord.
Your Worship, the only reason we have approached this Honorable Court is because of the fact that the competent authority issued an award. Subsequently, it was revised without informing the parties. And because of that, if they are aggrieved with the award, the first award, then it was their duty to approach the authorities to appoint an arbitrator and go for arbitration. In fact, under the Highways Act, there's no provision for review of the award.
The issue, my lord, involved is
We
that
go into section 3G.
3G5.
First is the award will be passed as per 3G1.
Yeah, Your Honor.
After issuance of notice under 3G2.
Yeah,
3G4 states that the persons concerned would go before the authority,
Yes.
competent authority, and submit their claims.
yes, Your Honor.
And 3G5 says that the competent authority can do so, and if somebody is aggrieved by that, they can very well approach on the quantum.
Yes.
But in this case, is it the question of quantum?
Actually,
It
yes,
is
my
the
lord.
case, it is regarding quantum, Your Honor.
Quantum.
It is regarding quantum.
Quantum.
It is regarding a quantum.
Yes.
Quantum of compensation, my lord.
The compensation which was awarded towards the quarries, stone quarries, which was given in the first award, was deducted in the second award,
Was reduced.
was reduced.
The amount is reduced.
Amount is reduced. And in fact, Your Worship, as per the first award, some of the landowners were already paid their compensation.
But then also, if we strike down this also, you can go under 3G5.
Yes. In fact, the Honorable Single Judge has given them liberty to approach the authorities for arbitration.
Huh?
The Honorable Single Judge has given them the liberty to approach the arbitration process. Para 20, Your Worship.
Yes, you are given the option, go there.
No, my lord, that we are not happy with the award is not the issue herein. It is the respondent herein who are not happy, who are not content
No,
with the quantum of award.
No, Mr.
So,
Counsel. Mr. Counsel, it's something like this. An award was passed.
my lord, thereafter
Now,
a
once
revised
the
was-
award, then they reviewed it and said that, okay, this particular portion of this should be reduced. That's done by the competent authority. The National Highways Act is silent as to whether it can be reviewed or not. But
Yes.
any person, if he is aggrieved by any award,
Yes, we'll have to go to the
can
arbitrator.
very well go before the authority, and that liberty is being given by the learned single judge.
They will first, my lord, the respondent will first have to go straight to the arbitrator.
You go.
In terms of,
You
no, my
go.
lord,
You are being given
we are
the
not
liberty.
happy, we are not content. It is not that we are not content with the award. They, being not content with the award, will have to go to the arbitrator in terms of 3G5.
You go.
No, my lord, because
You see
there
the
is
difference
specific.
between, see the language. Any party aggrieved by the amount, dissatisfied with the quantum, can go. So you
I
can
agree.
go.
I agree, my lord. I agree, but it is not us.
Don't
Who?
go. Very well, make the payment as per the direction. You don't go.
No,
we discuss
initially,
that.
my lord, initially, why they come before the lordship
Remaining
is
to go
against
to
the
Supreme
statutory
Court.
provision of law, my lord.
Mr. Counsel, remaining is to go to Supreme Court. You don't want to go, don't go. You have been given a due liberty.
My
There's
lord,
no limitation given.
Yes, as your lordship knows very well, when there is any statutory alternative remedy available, they usually will have to go. That is right law, as your lordship knows very well.
But they are challenging on the question of whether the power is there of the authority to review.
That also, my lord, can very well be raised before the arbitrator, my lord.
Why?
Because they are not
Can
happy.
the arbitrator decide on that aspect?
Yes, my lord, very well.
Show me where
There
the
is no
arbitrator
limitation,
can
my lord.
decide that.
Any person, my lord, if I may be allowed to read 3G5,
Yes,
my
please
lord.
read it.
If the amount determined by competing authority under subsection 1 or section 2 is not acceptable to either of the parties, the amount shall, on application by either, be determined by the arbitrator to be appointed by the central government. So that, my lord, involves all the issues, including the quantum. So initially, as
You are
admitted by,
going to appoint the arbitrator.
yes, already appointed.
I think there must be somebody who have already been appointed.
Yes,
Some
sir.
divisional commission.
Yes.
Who is appointed as the arbitrator for NHI?
Your Worship, there are 3 arbitrators appointed for different stretches, and they're all IS officers serving in the state government.
There are,
Whoever goes, anybody can go. Both of you, if you are aggrieved, you can go. He is aggrieved, he can go. Why trouble this court?
actually, my lord, they are circumventing that issue of 3G5, my lord. And now they are inventing this issue, saying that review cannot lie. But that actually, my lord, is not the issue before your lordship.
That is the main issue, Your Worship. There were two awards passed by the competent authority.
What is this 13/8/2021?
Pardon, Your Worship?
13/8/2021?
13/8/2021, Your
Where
Worship.
is the document?
Your
13/8/2021.
This is a notification of the state government.
Huh?
Notification, your lordship of the state government.
Where?
Page 85, my lord. 85 of the appeal. Herein the any revenue, any value,
Your Worship, we are concerned with para 5.
yes, your lordship.
Now, on the basis of this letter, the award was modified,
Yes, Your Worship.
revised.
Yes.
And
fact-
you are agreed by this,
Yes.
which
Yep.
is Annexure 7, page 87.
Yes. This, in fact, the award came before this. The award is in April 2021. The first award was in April 2021. Your Honor.
That is 17/4/2021.
Yes.
Is it?
Yes. Page 79.
Page 75? No, page 75, I think, page 75 is different.
79. Your Honor.
79, yes, that is the award. Reply to RTI. Is ready. However, 3G Part 2 could not be included and was not approved due to the state order. Dated Iman, you are hereby informed that the RTI. Now, how do you say that there was an earlier award?
Your Lordship, I'll just take your Lordship to that. If your Lordship will just give me a minute.
Page 80.
The RTI reply, Your Lordship.
RTI reply is this 23rd of September 2021.
There are two RTI replies.
Which one?
Annexure 5, Your Lordship.
Page?
It starts from page 45.
Page 45.
Page 45, running page. Annexure 5 of the writ petition, Your Lordship, I've not been given the running page number.
You don't have a memo of appeal?
I have a memo of appeal, Your Lordship. The pagination is cut. Annexure 5 of the writ petition.
Oh, okay, mention the document number.
Pardon, Your Lordship?
Is it the document of the RTI reply dated 23rd of
September
September
2021.
2021?
Yes.
How do you say that this
English
is
translation is at page 48, Your Lordship.
Huh?
The,
Yes, that is it, 17/4/2020.
yes.
But since there was an objection
Yeah.
or non-acceptance from the respondent number 2 and 3, as can be seen from the RTI reply. Here reply is here reply 23.
According to the reply, Your Lordship, there were two awards because of the letter issued by the.
We are not getting that now. Repetition page. In repetition, which page you are referring to?
Your Lordship,
Tell it from your repetition.
Your Lordship, para 12.
21st.
Para 12, Your Lordship.
21/9/2021, Annexure 5.
Yes. That, Your Lordship, the English translation is at page 48.
3A, copy Annexure 2, Iman.
This is the English translation.
1. Revise, copy Annexure 3. Revised.
Subclause B. Para 3, subclause B. Revised 3G part 2. Copy at annexure 4. The 3G part 2 is prepared twice. As the first one could not be approved by NHIDCL, the revised 3G part 2 was made in accordance with state order dated 13th of August 2021.
National Heritage.
So if your lordship will see, if your lordship will kindly see page 49. I don't know, running page 150. On the top right hand corner, this revised 3G part 2. Has your lordship got it?
Now, how do you say that it is an order of the competent authority?
If your lordship will,
17/4/2024.
if your lordship will allow me to take your lordship to page 150.
Yes, 150.
This is the revised award. Bottom left-hand corner, it is signed by one Margaret Lulrin-Moy Fanai,
Yes,
additional
is the
deputy.
competent authority.
Yeah, 18th of August 2021. And now, if I may take your lordship to Annexure 6, page 160. It starts from page 59. English translation is at page 60.
That is 17/4.
Yeah, page 162. Has your lordship got it? The table at page 162. It is dated 17th of April 2021 by Kala. So the first award was 17th of April 2021. Then the revised award was 18th of August 2021.
So the fight between both of you is who is going to go to the arbitrator.
Yes.
So
That is the
how
main thing.
Why should
Actually, Lordship, is since the earlier award was not approved also.
huh?
The earlier award, my lord, was not approved award.
What not approved means you have already authorized by a notification under section 3A, small a, to that particular person. Where is the question of any approval being granted by any authority here?
It is stated that that first award was not approved.
We dismiss your appeal. Heard Mr. So-and-so.
And yes,
We dismiss it. You go there. We don't find anything. You see, first and foremost, you have to understand one thing. In terms with section 3 small a, the central government appoints the competent authority.
my lord.
In terms with section 3G1, the competent authority is the person who is required to pass the order. The question of any approval or no approval does not arise. There is nothing out there. Unlike you require an approval for the purpose of issuance of a notification under section 3 capital A or 3 capital D, which the central government has to do. But here, this is there. You go there. You have been given the liberty, go there. You are agreeing.
Actually, my lord, even in the order, my lord, liberty given is contrary to direction issued therein in the same paragraph, your lordship. If your lordship may kindly go through my.
Yes. If such an application is filed, where it will be obligatory on the part of AR to deposit the entire amount awarded as per the revised estimate within 1 month.
My lord.
They are not aggrieved by the revised award, Your Lordship.
Petition is according to the further hearing that since there is no period of limitation prescribed for filing an application by a party aggrieved under section demand, is also granted to the respondent to avail the remedy available if so advised. If such an application is filed by the respondent, it will be obligatory on the. You are concerned with the rest of the portion.
My lord.
If such an application is filed by the respondent, it will be obligatory on the part of respondent to deposit the entire amount awarded as per the revised area within a period of a month from the date of the application a month before the respondent number 6. The respondent number 6 then disburse the
disburse,
amount to the month. So this portion you are agreed.
Your Lordship,
My
in
lord.
fact,
Exactly.
they are not aggrieved by the
it's
revised
actually
award.
contrary, my lord.
This is-
contrary to the opening made here.
This is regarding only the revised award.
So that
They
is
are not
why we
aggrieved
come
by the
before this.
revised award. They are aggrieved only by the previous
No, my
award,
lord.
the first award. Your Lordship, this direction regarding depositing is with regard to the revised award, which is not challenged by them.
It is, your
It is
lordship,
regarding
precedent
the
law.
revised award dated 18th of August 2021. They are not aggrieved with the revised award.
It is not a question of us being aggrieved or not.
Mr. Counsel,
Man.
kindly listen. You are not aggrieved by 18.8.
They are not aggrieved.
No, my lord, we are.
You are
it-
only aggrieved by 17.4.
No, my lord. Yes, my lord.
Then what is wrong in the direction
No, my lord,
with the 18.8?
Actually, since this direction made herein, my lord, cannot be complied with in it as it is, my lord.
Why?
Since it is contrary. Now,
No, there's nothing contrary out there. This is a violation of our.
and that is number one, my lord. Number two, when power is, as Lordship knows well, it is a separate law that when power is given to do a certain thing, it has to be done in that way only, my lord.
Okay.
So now, in terms of 3G5, my lord, anyone, including the respondent herein, who are not happy with the quantum, they admitted that, my lord.
They
There-
were happy with 17.4.
Yes, only that much.
They say
And-
18.8 could not have been passed. It's a case of revision. The power of review is not there unless there is an application being filed before the competent authority or before any other authority. That was not done. The competent authority cannot later on do whatever may be because the competent authority is the authority who has to pass the award.
My lord, yes.
He,
Anyway.
he becomes functus officio, Your Lord, after he's done his work.
Actually, that issue, my lord, they will have to go to the arbitrator, my lord.
You have to now go to the Supreme Court.
Kindly bear with me, lords.
Or-
Now, my lord,
No. Nothing doing. When are you filing? Within you file your application immediately and deposit immediately forthwith this amount.
that will have to
as
be
per
disbursed,
18.
my lord. And that will all go, my lord.
Huh?
That deposited amount will have to be disbursed, my lord. If we deposit it, and
Now,
that will
have
be
you
against,
deposited as per 18.8 or not?
There is no grievance against 18.8.
As per 18.8, have you deposited?
1880 is a revised one, my lord.
Have you
I do
deposited
not
or
have,
not?
I do not
my
have
lord,
any
I didn't have.
grievance.
We are not aggrieved with this.
So therefore, have you deposited as per 18.8 or not? As of now.
As of now, my lord, I have no instruction on that, my lord.
If you don't do it, then the entire thing has to go. This is a violation under 300A. This is the latest Supreme Court judgment. Return the land. This statutory provision under the National Highway Act cannot go contrary to Article 300A.
I
So
agree
we
on.
hold
I
this-
agree, with lordship, on that.
We hold this to be
Money.
unconstitutional and hold this with the entire acquisition to be bad. Go ahead and now again fix another as per the new rates. You want to do a fresh acquisition? Don't do it. Therefore, urge so and so, the learned counsel. So and so, the learned counsel appearing on behalf of petition appellant. The so and so appears on behalf of the respondent number.
Your Lordship, all the private respondents.
Private, Miss so and so
1 to 6 here.
appears on behalf of respondent numbers 1 to 6. Miss so who appears for the state of? Huh? You see appears on behalf of the respondent number 7, 8, and 9.
9.
The instant intra-court appeal is directed against the judgment and order dated 5/3/2024 passed in WPC number 106/2021, whereby the learned single judge had allowed the repetition, thereby directing the respondent, the appellants herein, to thereby opining that the petitioners therein, who are the respondent number 1 to 6 herein, would be entitled to receive compensation as per the award dated 17/4/2021, prepared by the competent authority of land acquisition, as well as also gives the liberty to the appellants herein to prefer an application under section 3G bracket 5 of the National Highways Act 1956, for short, the Act of 1956, if aggrieved with the quantum of compensation, and further also directed that the amount which was determined as per the revised award dated 18/8/2021 be deposited before the competent authority of land acquisition bracket Kala within 1 month from the date of the application made under section 3G5 of the Act of 1956. Full stop. For deciding the legality and for deciding the appeal, the present intra-court appeal, we find it relevant to take note of certain brief facts which are narrated infra. Full stop. Full stop. From the materials on record, it reveals that for the purpose of building bracket widening oblique 2 lane with paved shoulders oblique 4 laning etc bracket close maintenance management and operation of NH-6 bracket NH53 in the stretch of land from kilometer 15 to kilometer 30.05 bracket Office of the Deputy Commissioner Satyual SAITUAL PWD Weng Satyual SAITUL in the district of Satyual in the district of Mizoram in the state of Mizoram. The Ministry of Road Transport and Highways had issued a notification in terms with section 3A of the Act of 1956 to acquire lands as has been described in the said notification dated 11/8/2020. Full stop. Pursuant thereto, by another notification dated 29/9/2020, the notification under section 3D of the Act of 1956 was issued, and by virtue of the said notification, the land stood vested upon the central government. Full stop. It is relevant to take note of that in terms with section 3G1 of the Act of 1956, the competent authority who was duly appointed by the central government in terms with section 3 small a of the Act of 1956 had passed an award on 17/4/2021. Full stop. Thereupon, on the intervention made by the state respondent, by a communication dated 13/8/2021, another award was passed. Another order was passed on 18/8/2021. The petitioners herein, the respondent number 1 to 6 herein, who were the petitioners in WPC number 106/2021, being aggrieved to have preferred a writ petition challenging the jurisdiction of the competent authority for land acquisition bracket Kala to revise its award order passed under section 3G1 in as much as the Act of 1956 does not provide such a power of review. The petitioners therein further sought for direction that the payment of the compensation be made in favor of the petitioners, be disbursed in favor of the petitioners on the basis of the order dated 17/4/2021. The said writ petition was allowed by filing by the impugned judgment and award dated, the judgment dated 5/3/2024, whereby the learned single judge opined that the petitioner therein would be petitioners, that is the bracket oblique, the respondent number 1 to 6 herein would be entitled to compensation in terms with the award dated 17/4/2021 on the basis that the competent authority for land acquisition bracket color did not have the jurisdiction to revise its order passed under section 3G1. Full stop. The learned single judge further granted the liberty to the learned single judge further taking into account section 3G5 and the fact that and 3G5 of the Act of 1956 and the fact that the said and the aspect that the said provision provided either of the parties to approach the arbitrator in the circumstance the parties are any of the parties are aggrieved with the quantum of compensation, granted the liberty to the appellants herein to prefer such application. Full stop. The learned single judge further taking into account that the respondent number, the appellants herein, who were the respondents in the writ petition, were agreeable with the,
Not aggrieved. Not aggrieved. By the-
were not aggrieved with the quantum as per the award dated 18/8/2021 directed the appellants herein to deposit the said amount within 1 month from the date of filing of the application under section 3G5 of the Act of 1956. Full stop. It is being aggrieved. The instant appeal has been preferred. Full stop. This, we have duly heard the learned counsels appearing on behalf of both the parties and have given an anxious consideration. Full stop. We have also perused the provisions of section 3A, small a, of the Act of 1956, which empowers the central government by a notification in the official gazette to appoint a person to perform the functions of the competent authority for such areas as may be specified in the said notification. We have also perused section 3G1 of the Act of 1956, which empowers the competent authority to determine the compensation and to make payment and to determine the said compensation and to pass an order. It is also relevant to take note of that the provisions of section 3G do not provide that the competent authority, once after passing of an order in terms of section 3G1, had been given the jurisdiction to review its order. Full stop. Under such circumstances, we are of the opinion that the learned single judge was justified in passing the impugned judgment and order, thereby holding that the petitioners herein would be entitled to the compensation. The petitioners, the respondent numbers 1 to 6 herein, would be entitled to the compensation in terms with the award dated 17/4/2021. We have also taken note of section 3H of the Act of 1956, which categorically stipulates that the amount determined under section 3G has to be deposited by the central government in such manner as laid down by the rules made in that behalf by that government with the competent authority before taking possession of the land. Full stop. Taking into account that that is the mandate, we are of the opinion that the petitioners who are the respondent numbers 1 to 6 herein, would be entitled as to the payment of compensation in terms with section 3G, in terms with the order passed under section 3G1, that is the order dated 17/4/2021, and the competent and the central government ought to have made the payment of the compensation, ought to have deposited, is required to deposit as being statutorily obligated in terms with section 3H1 of the Act of 1956. Full stop. Under such circumstances, we find no infirmity in passing of the in the impugned judgment and order passed by the learned single judge, and accordingly we dismiss the appeal with cost 10,000.
No, my lord.
The cost. We dismiss the appeal. Full stop. Before parting with the record, we make it clear that the liberty so granted to the
Appellants.
before parting with the record, we make it we feel it obligated. We feel it necessary to observe that non-deposit of the amount by the central government of the compensation in terms with section 3G1 as determined by the competent authority would amount to violation of Article 300A of the Constitution, and as such, we direct the central government to, if not deposited, to deposit the said amount as in terms with the order, in terms with the deposit the said amount in terms with the award dated 17/4/2021 within 15 days from the date of our order.
If I may, Lordship, the direction before the learned single judge was in terms of
18.8.
18.8 mile.
But 18.8 cannot be there. We modified it. Because you see, when the learned single judge have already held it, that it should have been, they are entitled to 17.4. The learned single judge was very lenient. Was very lenient to say that, okay, this is an admitted amount, so you pay this. You cannot. This is an when the learned single judge held that they are entitled to 17.4, 17.4 is the amount.
Obliged.
Item number 3.
I seek a lordship apology in not taking immediate steps for service of notice to the respondent number 6 and 7, 10, 11, and 12. Even though I was directed to take steps by the order of this court on 11/9/2024. My lord, I have taken steps to the respondent number 6 and 7, 10, 11, and 12 on 22/10/2024.
Now, what is your case?
Your lordship will see that there was a specific direction by the order of this court.
You filed a writ petition.
I'll file a writ petition which was dismissed due to the observation made by the learned single judge that there was a disputed question of fact. Now, there are several aspects with regard to this. The award number 1 of 2018 was passed by the district collector, which was approved by the state government. And this,
This is under land acquisition.
it was under Land Acquisition Act 1894. So there was a blame game between the respondents, the executing agency, and the Union of India. Your Lordship will see the
No,
direction
the question
passed by
is
the,
whether the award has been passed or not.
it was passed, it was approved by the state government. It was approved by the state government on 31/7/2018.
Show us that document. This is the award. Page 310.
Yes, my lord.
Award 1.
Award 1 of
Construction
2018.
of the Indo-Bangla border fencing IPBF and its approach road under.
Now, the respondent have sought to challenge this award since they submitted that the award, the draft award, did not specify any dates. However, subsequently, it was approved by the state government. Your Lordship will see that subsequent to the filing of this writ appeal, there was an order passed by this court.
So this was on 8th of April 2013, Section 6 declaration.
Yes, 8/4/2013.
8th of April
Yes,
2013
my
is
lord.
the Section 6
6 declaration.
Then
Section-
award passed when?
Award, it does not specify any date, but it was approved on 31/7/2018.
Oh, this award has gone for a 6. How can there be an award at all?
Now, my point,
Now whose land? Has your land been taken over?
yes.
Tell me.
My lord, the construction of road has been done in the year 2007. However, after a lapse of 13 years from the construction of road, they have passed this award. However, in the award, there is not mentioning the date of award when
Whoever
it
the
was
date or
issued.
anything, I'm not on that.
Yes,
But the fact that, have you taken the possession of the land?
yes, my lord. We already make a payment in the year 2007. Whether the
So
state government,
without acquisition, you have taken over the possession of the land of the petitioners.
my lord, at that time, whether it rightly or wrongly, that the state government may not strictly apply the Acquisition Act, my lord. However, we make a payment as per assessment made by the state government at that relevant time in the year 2007 for the same stretch of road, my lord.
So 2007, there was no acquisition at all. Acquisition started later on. Kindly see this.
My lord, that award number one of
kindly see-
2008 has been
Madam,
issued
kindly
on
see-
that.
Notification is
madam,
2012.
Kindly see page 303, that is annexure 1, I suppose, 26th of October 2012. This is the first time when the government initiated the process by issuance of a notification under section 4.
My lord, however, in this award, there is nothing mentioned the stretch of road which is to be acquired, my lord. In the meantime, they had already acquired the land in the year 2007. That is the problem. That is why the landed single just opined that this award seems to be fake, my
No,
lord.
no, this award goes for a 6 because of the fact that it is in violation to section 11A. You see 11A.
Yes.
11A says within 2 years from the date of declaration under section 6,
Yes.
you are to pass the award. And if you don't pass the award, it lapses. The entire acquisition proceedings lapses. So therefore, what is required is you have to either acquire the land, if it is the land of the petitioners that have been taken. The question of making payment or non-payment is, you would be happy enough. The state should be happy that on the basis of this amount, you are paying it.
But the same has been countersigned by the DC also, my lord.
Huh?
The same has been countersigned by the DC. District
Countersigned by
collect.
the DC.
Yes.
No, we are not concerned with that. The fact that the approval came in the year 2018 makes it clear that it is beyond 2 years it has been.
13 years
So
from.
this is absolutely, this type of award cannot exist in the eyes of law. But on the other hand, if you have taken over the possession of their land, this is in violation of Article 300A. Yes, state government. Who is appearing for the state government? Yes, tell me, what type of this the acquisition is this? You are to therefore tell this court as to whether there was an award or not. The award has to be approved. The approval came in the year 2018. And in terms with section 12, you have filed, you have submitted, you must have filed it before the authority in your office. And it becomes a conclusive piece of evidence between the deputy commissioner and collector and the persons interested. But can it be done in terms with 11A? Then how is it possible this is happening? Whether date or not date, but how can you take over the land? You return the land. You cannot, without acquisition, this is not done. Take over the land, return the land to them. Mr. Counsel, you'll be happy?
I'll be happy with the money.
Land. Take over the land, let them acquire again. Then you will get as per the 2014 rates.
Mano, they are high and mighty. They
Because
have
their
they have
award
every
which was-
resources.
The award which was passed,
Malo.
they have applied section 23 of the old act.
Malo. Yes.
Now, you'll be entitled to 100% solution.
Correct. Malo.
Then you'll be entitled, being in urban, on the multiplication,
Yes, Malo.
it will be double. So under such circumstances, you will be entitled to much higher, and
Malo.
now they will has to do it as per the present rate.
I agree. I agree with your lordship because I have taken that grounds in before the learned single judge,
Yes, take that.
which was
My
not
lord,
considered.
even though the learned single judge has given a right to approach the appropriate forum, because
No,
since
we
disputed question of facts has been involved in the
Madam,
case.
we allow his petition. We say that he is entitled to the land. There is no acquisition. There is a violation of Article 300A. So return the land back to them unless you acquire within 6 months from today. Fresh acquisition. That acquisition has gone for a 6.
My lord, I'll be happy with that because that was my prayer before the learned single judge.
Return the land.
My lord, whether the
This award cannot happen. You are therefore required to go ahead with a fresh acquisition. Yes, government. You are to go ahead with a fresh acquisition. You cannot on the basis of this have it because their rights have been taken. And in the meantime, you pay them, if you have taken the land, pay them restitution, whatever, take it as a, what you call the requisition, the temporary requisition, which will be in terms with section 35 of the old act. Pay them compensation. Give me the land. This cannot happen like this. We have neither paid any compensation. You cannot do this. It is not, it lapses in view of section 11A. In 2 years. The collector shall make an award on the section within 2 years from the date on which turn the land. Here in the last order,
Yes, my
My
lord.
lord.
which have been passed by on 11/9/2024, more particularly at paragraph number 15, this court have already opined this aspect.
It has made an observation.
We have perused the award dated so and so, and we have the view that as the award dated has been made in the year 2000 on the basis of a declaration under so and so, the award is hit under 11A and the 2013. As such, it appears that the award dated cannot be acted upon. So there is no award.
My lord.
So under such circumstances, you have to go for a fresh acquisition. You have not challenged this before the Supreme Court.
No, they have not
Not,
gone
not,
there.
Any of you?
They have not gone there.
So here, what is your prayer, your writ petition? Let us see.
My lord will see at page 298.
Page
298.
Why are you asking this? So as of now, there is no award.
Yeah, I understand.
So as of now, there is no award. Here, the land has been taken from you without following
Due process of law.
due process. And as such, it is hit under Article 308. That's all.
I agree. I agree with your lordship.
And then with directive, within 6 months, complete the acquisition proceedings. If you don't do it, return the land. That's the only way. That is the only way. Else, return the land. Why do you let else? Question of compensation, don't ask for this type of compensation. This is too meager an amount.
I bow
for
down.
something big.
I bow down.
Okay?
My lord, if I may permit it, as per the last court order, my lord, at para 16, if I may read, my lord, we are of the view of the state government / CIDC will have to produce all the original LSC mentioned in the award number 1 of 2018, along with all the official record pertaining to the approval given by the Government of Mizoram / CIDC for issuance of the said LSC to the petitioner, as would be like to see for ourselves whether the LSC are prima facie genuine.
No. Why should we look into all these things? When there is no award as of now, the question is this: you cannot take away their rights over the land. Go ahead. Go ahead with a fresh acquisition. You are the best authorities to do, not you.
Yes,
They are the best
that's right.
authorities to look into it as to whether it is genuine or not. We don't have the discourse cannot have no as to whether this particular document is genuine or not. It will be based on evidence. But if you don't do it, then you have to return the land. The entire acquisition has gone. It is absolutely illegal possession. Your possession is illegal. You are in possession. You are in
For
possession of the land.
construction of road only, my lord.
Huh?
For construction of road only, it has already been done in the year
Whatever road
2007.
That is your lookout. For that, can you take over somebody's rights?
But as far as my knowledge is concerned, my lord, due to the state government at that time did not follow the acquisition law, strictly not followed. However, we make a payment as per assessment made by the state government at the relevant time. That was in the year 2007, long time back, my lord.
But there is no acquisition. Then, was there any acquisition? 2007? No acquisition.
My lord, whether it was rightly or wrongly, however, we have paid as per assessment made by the state government.
No, you have paid. You take the money from the state government. They may do whatever they feel like. They have not. They have taken the money from you and they have not paid it to them.
No, Lordship, even the district collector
Because
does
obviously-
not have any knowledge regarding
Huh?
the payment. Even the district collector does not have any knowledge regarding the payment of the compensation in 2007.
No, nothing. We allow the repeat. But not the repetition in the manner in which you ask.
My lord.
We hold it that it is an acquisition is absolutely, there is no acquisition. If the possession is taken, it's absolutely illegal. So we give them 6 months time for the purpose of this. That's it.
If I may not be tedious to your lordship, since they have occupied my land since the year 2013, they took possession of my land. Now, if your lordship permits me to get rent for that unlawful occupation,
Huh?
rental charges
No, it's just for construction of road, my lord.
before taking possession, my lord, because they have
You
been
have mentioned in your petition.
no,
No,
I have not mentioned that.
Beyond his, his
I have not
prayer.
mentioned that.
Beyond
But
his
due to
prayer.
observation made by your lordship,
They can't give you so.
my lord.
Now, if there is no award, the question of payment does not arise.
My lord.
But if your land has been taken away without following due process, now, did the state file their affidavit?
They
in
have
the
filed.
repetition?
They have filed.
Yes.
What is their stand? Let's see.
Page 108.
Huh?
Page 108.
108.
No, my lord, that is my writ appeal. 602.
Page 600.
The relevant portion is from page 602, para number 5.
What? Does anybody say anything about the possession?
I have mentioned in my writ petition.
No, as regard them.
No, they did
No,
not
they
say.
also filed an affidavit, no, BRO.
Yes, my lord.
Yes.
I
Actually,
believe they
yes,
have not mentioned
But the
anything
The affidavit is the
rebutting my
page is a very
Statement.
important page.
Midang ho affidavit akan yakin. Ini petition. The page 440 and look there, para number 13. Number 14. 13. Zero masih construction. Ah, kilo ba? Construction, construction, silo.
Now, what is the present status of the land? Where can we find it? Something is required, no? Here at page 431, paragraph 4, you have mentioned that as stated in the writ petition and in reply to the incident paragraph, the petitioner submits that BRO had made payment to some of the petitioners herein only for damage to the crops within 4 months,
4
4
meters.
meters of the fencing and no compensation for the market value of the land, including solatium and interest, have been paid to them and other petitioners herein for compulsory acquisition of. Where do I find that they have taken possession? Somewhere.
My lord, that, as far as my knowledge is concerned, that is not there. The statement
let them
which was
say
made by me has not been rebutted by the respondents in their affidavit.
Government to be incorporated in the year 19. So NPCC says that they have nothing to do.
They have nothing to do, they say like.
Who is paying for NPCC?
As per the last order, the direction has been given to the petitioner.
My lord, we have taken steps of service of notice to the NPCC on 22nd 10 of 2024.
Let the opportunity of being heard may be given, my lord, to the all parties.
Yeah, we got it. 448. This is the affidavit of NPCC. The third paragraph. The compensation for the land acquisition for IBB fence and road in 20 kilometers land from village so-and-so to so-and-so in a width of 8.27 meters was not in the scope of NPCC, but as per knowledge was in the scope of BRO. But records pertaining to land acquisition for the same has not been handed over to the NPCC. Was not acquiring department for the land acquired under so-and-so. Respond number 7 and 8 by later communicated the same and returned the award with a request to approach the concerned authority. So NPCC denies any involvement. But there is a fencing now.
They were the executing agency, NPCC. They were allotted a contract work for that fencing. Now the acquiring department is the Union of Government, Union of India, Home Department, BSF. It was acquired for the purpose of border security.
My lord, the land has been handed over to BSF by BRO in the year 2010.
Now, your possession has been taken when?
2013.
All.
Yes, my lord.
So you come in the second batch. There are 3 batch. One is the 2007, which was handed over in 2009. The second is the 2013, which was handed over in 2015. And the third is yet to be handed over. Come to page 441.
Yes, my lord. It is the stand of the respondents that for these villages, they have already paid compensation. It is the stand of the respondents, Union of India. But that was not done
No. Therefore, I'm saying,
My
you
lord.
see, the construction of the work of fence and road started in the year 2007. Means if your possession was not taken till 2013,
My lord.
it could not have been. Kindly see, on
Yes.
completion of the fence from so-and-so to so-and-so and the alignment in so-and-so, it was handed over to the BSF by BRO on 7/7/2009. So this area is outside yours.
No, it is the land which we have claimed. And the land,
Kindly come to the next part.
my lord.
The remaining part of the fence from chain is 59.10 kilometers to 69.10 was constructed by NPSCC and
NPCC.
handed over to the BSF on Iman and Iman. However, 20 kilometers road constructed along with the fence from chain so-and-so was handed over to the CPDA by the BRO.
My lord.
Now, this chainage is from where to where?
Our land covers from
My lord,
49
nothing
to
has been
69.
mentioned in the award. That is the main reason. Nothing stretch of road has been mentioned in the award number 1 of
Oh, it
2018.
is there. We'll see from here. See the
They just
notification under
take,
section 4. Stretch of land along here, approximately 120 kilometers due, certified amount.
it pays 481, my lord. That is award. Nothing has been mentioned about the stretch of road, which is required to be acquired.
Statuses and process number. Section 6, can you give it to this? Private land consisting of. Now, how did you know that your land is being acquired as per this acquisition proceedings?
Your lordship will see at the draft award.
Now, kindly come to page 303. But, madam, tell me, if you are appearing for the union,
Yes, my lord.
all these have been done at the behest of the union. Be it BRO, be it BSF, be IT, BB, or whatever may be, or be it NPCC, everything has been done for the Union of India. The state is exercising such power on behalf of the Union of India.
Yes, my lord, right.
Now tell me whether there was any acquisition as per Union of India.
My lord,
Acquisition has to be, madam, kindly understand, I'm making it clear. a transfer of a land from one person to other authority,
Yes.
what do you mean? Either can be on the basis of a deed of conveyance, transfer deed,
Yes.
or by virtue of a statute. You have to vest the ownership somehow.
Right.
Therefore, if you see the National Highways Act, the Land Acquisition Act, the Right to Fair Compensation Act,
Yes, right.
you will see
Yes, my lord.
in terms with the National Highways Act, Section 3D2 categorically mentions that once the notification of Section 3D1
Right,
is
right.
being issued, the land automatically vests upon the union.
Yes.
So this is by way of a statute.
Yes.
Secondly, if you see the Land Acquisition Act 1894,
Yes.
the moment an award is passed, the land does not vest. When an award is passed and possession is being taken in terms of Section 16, the land vests upon the state.
Yes. Right.
Okay? Now, here in this case, they did not exercise the powers under Section 17(4), which is apparent. Thereby, the emergency power have not been exercised. So, when will be the vesting of right upon you or the state government? It can be done only
Yes.
on the basis of an award being passed, which is in accordance with law,
Yes. Right. Right.
as well as on the basis of possession being taken pursuant to the award being
Yes,
passed.
my lord. Right.
Now, if that is not being done in terms with this,
Yes. Right. That is the failure of the state government. We just
understood,
consult
but
with.
at the cost of your union. Because tomorrow, this acquisition has to be done.
Yes.
Because after all, these people have some right. Maybe all may not have right, but some have some rights.
Right.
So under such circumstances, there is the requirement of either purchasing, go and purchase it by sale deed, or by way of an acquisition.
Yes. Right.
So otherwise, you cannot take away.
Right. However, we just consult with the state that we have nothing to do. However,
No, you have nothing to do. No, you are
But-
the person who are going to
Yeah, my
lose
lord.
the most.
we approached the state government for taking acquisition of the land. But however, the state government at that time not strictly followed the land acquisition proceeding. That is the main problem.
So there, as of now, there is no conferment of right. So the land still belongs to them, and you are illegally in possession of that land. Return the land.
My lord, from our side, we have made a payment on the stretch of road as per assessment made by the state DC. Then we have no more existing liability for repayment of the.
Why you are not paying him 31 crores and let him say that you go for.
My lord,
consent
we
order.
already make a payment 40 lakh something in the year 2007.
No, madam, why I'm saying so? I give you, we have it on Monday. Take a call. Why I'm saying so? Tomorrow, if an acquisition happens, this 31 crores will go to almost 300 crores. Remember that. With the new act, with the price going up, all this, instead of that, if you can culminate it into a, in view of section 11(2), 11(2), no? 12(2), 11(2). Something can be done in terms with section 11(2). Notwithstanding anything contained in subsequent, if at any procedure the collector is said all person interested in the land who appeared before him has agreed in writing on the matters of included in the award of the collector in the form by the rules made in by a bird, he may without making one and make an award according to the terms of the agreement. Now, if these petitioners out here are asking for these 31 crores, think about it. We are thinking about the Union of India also, but the fact is otherwise it's a case of a 300 crore. We have it on Monday. Take a call. Ask your people what to do. Because as of now, the person who, the authority who is going to face the problem is you. The award has to be passed.
But however, my lord, the award seems to be fake.
Huh?
The award number 1 of 2018 seems to be fake because there is
No,
no
there is-
mentioning the date. Then
Madam,
that was
Can I tell you? If the award is said to be proper, it is more beneficial for you. But the award is not in existence. There is no award in the eyes of law. Fake or not fake is material. You should be happy with that award. I'm paying only 31 crores. It is he who should have challenged the award. He has not done it.
However, my lord, due to failure of the state government, how can we pay more and more of the compensation?
At the end of the day-
We are ready to pay as per Acquisition Act in the year 2007. However, due to the failure of the state government not
We have it on Monday.
yes, my lord.
Okay?
Yeah.
We'll pass the order on Monday.
Okay.
You think about it, what is to be done. Otherwise, we have to set aside this.
Okay.
Already the division bench has already opined that it is nothing is there. But why should we go into those intricacies as to whether there be genuine LSCs or not? It is for the authorities to will know it.
But I mean that, my lord,
These LSCs can be looked into by the authorities. Let them do it and go ahead with an acquisition of that. And madam, you get your instruction, which area
Yes.
have been taken. Get your instruction to that effect. Means these two villages and where,
7
in
villages.
which area? Because your notification which was issued under section 4 is also vague, absolutely vague. It says 121 kilometers. My goodness. And how much is long is the border with Bangladesh? 121. And the entire one.
It's very big. In the award also, it's very big.
Because NPCC gives a more clearer picture in their affidavit, and more particularly at page 440, 440 and 441. It's a clear picture as to from which chain to which chain. There's no award, nothing. The matter having been heard at length, we further find it necessary that some additional opportunity be given to both the state as well as the union to make additional submissions on Monday. It's recording this on Monday. Give the data.
Obliged.
For orders, item number 4.
Orders. Delay. What is this? Condonation, how much is the delay? 188
One word-
days.
yes, Lord.
Notice issued.
my lord.
Who is appearing?
Speak.
Oh, you have not taken steps.
No, this is the first time, my lord. The first time.
First time you have not taken steps, we impose cost. You have not taken steps.
Notice, my lord, will have to be issued first.
Reference to the order dated steps not taken by the learned counsel for the applicant till date. AD card not returned back from remand. However, since the weeks is over late before the division, please verify.
Oh, apologies, your lordship. Apologies.
Shall take steps for service of notice upon respondent number 1 by registered post with AD. Have you taken that?
My lord, I'll, with deep apologies, your lordship, I'll take step, my lord.
You have not taken.
My lord.
Let us
Apologies.
then see
Deep
your
apologies.
case on merits. What do you have? We then dismiss your case here only. Why should we trouble you of paying any additional amount?
Apologies, deep apologies, your lordship.
Not necessary. Why are you filing this appeal?
Actually, my lord, the land of that private respondent, my lord, was not utilized.
No, it is a dispute between you and the person concerned along with the competent authority. The competent authority has been asked to, is the petition is disposed of with a direction to make a proper, appropriate assessment of the value of the land of the petitioner, which was affected due to construction of the work along with all other statutory benefits as may be available to him as per law within a period of 1 month from the date of receipt of the certified copy. Upon finalization of the assessment, shall forward the same to the respondent number 528, who shall then deposit the assessment accord amount to so and so.
There is, for that, my lord, one letter issued by the NHIDCA, lordship, way back on 5th of September 23, lordship.
So the petitioner has been given amount towards payment, compensation towards
crop
crops
damage.
and trees,
Crop
but
and
no land has been given.
No land value, my lord.
So
No land
the
value
court, the petitioner sought for information. In reply, the petitioner was informed that all the period holders have been paid compensation towards value of the land and their period was left out due to some technical errors.
That,
So
my lord.
this was only directed to be corrected. What is wrong?
No, my lord, actually on ground, it is not that the land was utilized.
Huh?
The land was not utilized, lords. So for that, my lord, if your lordship may kindly take a look at the main writ appeal, lordship. Writ appeal, I think will take, have
That
to
is
take-
what I'm looking into, the main writ appeal on.
My lord, for that, my lord, page 62, my lord, annex the 3.
Who is appearing for the government? You are there?
Yes, Lordship, I'm.
You get your
appealing for it.
instruction as to whether this order has been complied with or not.
Yes.
If it has been complied with, we are dismissing his area. We'll have it on Monday. Ms. So-and-so appearing on behalf of the state Mizoram shall apprise this court as to whether the order dated 16/11/2023 they passed in WBC number 104/2023 have been complied with or not. We have it, this order, pass it in the IA, huh? If it has
Obliged.
been done, nothing is there. We dismiss your petition.
For admission, item number 1.
Yes, Mr. Gupta.
May I please, my lord? My lord, in this matter, my lord, the affidavit has been filed by the private respondents, my lord, which was filed on Friday, my lord. I have not received the hard copies yet, my lord, although soft copies have been supplied. But may I pray, my lord, that the matter may
Item number?
take 1, my lord.
Item number
1.
1, the appeal is filed by the Union of India.
Yes, my lord, appeal is filed by the Union of India. Notice was issued,
Then what do you want?
and my lord, as per the last order, my lord, there was a direction that the private respondents can file affidavit also.
Forget about
So,
the
my lord, the
affidavit.
others, the private
We are not
respondents have
concerned.
filed the affidavit.
You're not concerned with affidavit business. Now tell me, what do you do? What is your case? What is your case? Your case is on
Lord-
section 28 and
But
34.
our case is, yes, my lord. Interest under both these sections, my lord, cannot be granted, my lord. That is our,
But
our,
Mr.
our
Gupta,
submission
tell
is
me
that,
one
my lord,
thing. Whether there was a
my lord.
reference proceedings.
Yes, my lord, the parties, my lord, in this case, my lord, they have come under 28A. Not, there was no reference proceedings.
So if there is
These
no
set of
if
petitioners,
there is no reference proceeding, how does 28 come into play?
because, my lord, in the original, before, when the LA, in the original land acquisition proceedings,
Huh.
my lord, they were the owners. They were the landowners.
Huh. Then?
They were the landowners. And similarly situated landowners, my lord, they filed reference before the Honorable District Judge under Section 18, and the land value was enhanced. The land value was directed to be given. Initially, the land value was 0. Thereafter, once the similarly situated landowners approached under Section 18 by filing reference, my
Then
lord,
they cannot approach under section 18. They can only approach under section 28A.
no, they were aggrieved by non-granting of compensation for their land. That is why they have filed the reference under 18.
Within 6 months.
Yes, yes. That was in time, my lord.
Then
Now, my lord, since similarly situated landowners were granted the benefit of land value, meaning thereby, my lord, the land value was increased from 0 to 25 rupees.
by whom?
These by the reference court.
So it was by the reference court.
Yes, yes.
Okay. Then
And these, my lord, set of petitioners, they have come under 28A claiming the benefits as the landowners who were similarly situated. They were granted enhanced compensation under Section 18. So they should also be given the, my lord, the land value at an enhanced rate. Then, my lord, these set of petitioners, my lord, the enhancement.
then
Now, my lord, is regarding the
yes, Mr. Malhotra. What is this case about?
Act and another under Section
Mr.
34.
Gupta, it is very difficult for you to hear it. So we will hear the respondent and dispose of the appeal. Tell me.
Your Worship, if this matter may kindly come up next week, Your Worship.
Huh?
Because my learned friend had requested that he'll be seeking some time.
No, he's not required to take some time. We are not there. You tell me, what is your case?
Your Worship, our
You
case-
filed a writ petition. Why?
because Your Worship, the other landowners who had filed a reference petition, they were granted the land value.
Higher compensation.
Yes. So
Then you moved under what?
28A.
28A.
Then that was rejected, but we went to the High Court. The High Court remanded the matter to the collector, and the collector awarded the land value as per the reference court order.
How?
Because
How can the collector award?
as per the directions of the High Court, the matter was referred to the collector.
Show me that order. Where is that
It's
order?
And then, Your Worship, in the affidavit filed by the respondents,
Page 93?
page 40,
Page?
annexure 4, page 40.
This is the order of
In WPC 121 of 2016.
$129. No.
WPC 121 of 2016.
Mr. Malhotra, there is a huge, always a problem whenever you are appearing with the page numbers.
Page 40.
40 is what?
Affidavit filed by the respondent.
No, we are in a writ appeal.
Your Worship, writ appeal.
Writ appeal, that document is not there. So this is the document. Or Mr. A.R. Learned Counsel appearing the petitioner claiming to
Copy the I writ appeal. British law 128.5.
A. When was the first reference court award passed? Under section 18,
Your Worship, that was in LA case number 30 of 2014.
30/2014.
2014. Yes.
Then when did you file your application?
That was passed on 5th of February 2015.
5th of
February 2015.
5/2/2015.
15, yes.
And when did you file your application?
1/5/2015. 1/5/2015.
1/5/2000?
15.
So within 3 months.
Yes.
So that was allowed.
Yes. Your Worship, that was initially rejected.
So but because of that, the court directed it.
High Court
and
directed,
then they allowed.
Yes.
And then they enhanced the compensation.
Yes. Your Worship.
Now, once the enhancement of the compensation was there,
Yes.
as regards the value of the land,
Yes.
the corresponding, their interest in terms with 28 came into play.
Yes. And
Now, once 28 comes into play, 28 is in respect to the additional amount. Where
enhance amount.
Interest.
yes.
Yes.
Now, for that, we may have to look into the judgment of Gurpreet Singh, Mr. Gupta,
Yes, my lord. Gurpreet Singh. Yes, my lord.
Constitution
Yes,
Bench,
Yes, yes, my lord.
paragraph 51,
2006, my lord. 8 SCC 457.
paragraph 51.
2006.
Paragraph 51.
50 or 51, read it.
I will read it.
Gurpreet, first comes Sundar, then comes Gurpreet Singh.
My lord.
Sundar was as regards the compensation interest.
Yes.
Then comes Gurpreet
Yes.
Singh.
Yes. Paragraph 50.
I think they will be entitled to interest in accordance with that paragraph.
Yes, my
It
lord.
categorically mentions very clearly, that paragraph says how the payment is to be made.
Yes, my lord.
Yes, read
Yes,
it.
ma'am.
Let us be knowledgeable with Mr. Gupta.
My lord, at the moment, my lord, my humble praise, my lord, because the affidavit has been filed, my lord.
Forget about
Physical
affidavit. We
hearing-
won't require affidavit. Affidavit. Where is the
Physical
question of
hearing,
filing
my lord, would-
affidavit? Mr. Gupta, where is the question of filing affidavits in writ appeal?
Yes,
So forget about the affidavit. We concerned, we be more interested.
my lord, may I pray, my lord, since, my lord, physical, I think, my lord, would be, because lot of judgments, my lord, I have to rely. Physical, my lord, I am,
Why do you require
next
so
week,
many
my lord,
judgments? The law is very clear. The Constitution bench have categorically held that.
Yes.
Where's my iPad? Yes.
Paragraph 50. And we-
또는 CMA 파파 다대로 연감인 저한 CMA 가다
ये पकड़ना है, yes, yes.
안됐다 그렇게 아팔라고 payment tadi ya. Tadi 20 payment. Ini apa?
English.
Ini ganti 20 Oh, 34 también beta. Esta negue un jesu 34. No, 34. Ini beta, ini beta. 34. Yeah, ini beta. Betul.
This Sundar judgment is when?
No, it is 2001, 7 SCC 21.
Sundar. Sundar versus
Union of India.
Union of India.
Yes.
Monday. At 10 in lunch.
2001,
But 7 SCC, 211,
7 SC,
211,
2,
11, my lord. 211.
and good pitching is what? Your internet is
My
very
lord,
bad. It's too bad. Sundar is 2000. Yes, where's the good pitching judgment? You have it?
Your Worship,
my lord, I have given the list of judgment, my lord. It is in the file, my lord. 2 sets I have given. The citation is, my lord, 2006 8 SCC 457.
6, 8 SSC.
457.
You will get the list of books, no?
Paragraph 44, my lord.
Paragraph
44.
Yes, 52. I told you 52. What is to happen when a part of the amount awarded by the reference court or the appellate court is deposited pursuant to an interim order? This is interim order, no? This is nothing to do with it. Once the motion is
good pitching.
no. Can't help it. What to do? We allow the appeal.
Your Worship, can we fix it on Monday?
We'll allow the appeal.
Your Worship, because
Judgment is wrong.
Your Worship, I mean, the prayer of the present respondents in the writ petition was for interest under section 28. And
The section 28 will be only as regards those excess additional amount.
Yes, Your Worship.
34 is from the date of taking over possession, first year 9%,
Yes.
next 15%. This is on the entire.
Yes.
Now, just for example, 1,000 rupees is the amount which was found by the collector initially.
Yes.
Now, 1,000 rupees, against that 1,000 rupees, you are entitled to compensation to that affair. You are entitled to interest for the first year from the date of taking possession at the rate of 9%.
Yes.
And against the second year, from the next year,
15%.
15%. This is 34.
Yes.
Here it comes as regards the collector makes it in terms with section 28A 1,150
Yes.
means an addition of 150.
Yes.
Against that addition of 150, you will be entitled to interest from the initial point if you have not been paid compensation for that period.
So, yeah.
That's it.
So my submission, Your Worship, is that as per the reference code order, the land value was given, the compensation was enhanced. Then we also filed a claim under 28A, which was rejected by the collector initially. We went to the Honorable High Court. High Court directed the collector to consider the representation, the claim. Accordingly, the collector increased gave us the land value as per the directions of the reference code, which was in the analogous case. Thereafter, those landowners in LA 30 of 2014, they applied for interest under 28 and 34, which was granted by the reference code, and the railway authorities paid.
They will be entitled to interest. Therefore, I'm saying
Yes.
the interest as per 28 will be only in respect to the enhanced amount.
Yes, Your Worship. That is what we are claiming.
And interest on 34, you have already got the amount.
Yeah, but now we are claiming 28.
So 34, on Mr. Gupta, they will be entitled only in respect to the enhanced amount.
Yes,
That portion only, they will be entitled to interest as per 28.
28. Yes, my lord. Yes,
They
my lord.
would not be again entitled to, if they have just for example, which I have given the example, 1,000 rupees was the amount fixed. You
My
have
lord.
paid within the 1 year, then you are to
Yes.
pay 1,000 plus that period at 9%.
9%.
If you have
yes.
paid after 1 year, so for that is a closure. It is closed. Now
My
for
lord.
additionally 150, which is there,
My lord.
these 150, they will be entitled to interest from the beginning.
Yes, my lord.
Only against that 150. That's the law.
Yes, my lord.
That is
That
what
has
we
been
see.
paid. That has been paid to them.
Now,
that
have
was
you
paid to
it
them, my
on
lord.
on the enhanced amount. Have you paid?
Yes, that was paid to them, my lord. Already paid to them.
When?
That enhanced amount already paid to them. That is why, my lord, we filed a petition.
No. The enhanced amount
My lord.
has to be paid from the date you have taken possession.
Yes, my lord. Yes. Yes.
But it happened only in terms with an order passed under 28A.
Yes. Yes.
The example is 1,000 rupees. For 1,000 rupees, you have already paid along with interest, 34 done. So 34 is wiped out. Thereafter,
Yes.
34 has no application.
Yes. Yes.
150, which is the additional amount, there the lie would write from as per 28 only there you have to pay. Nothing.
Yes.
34 does
Yes.
not come.
Yes, my lord. That, my lord, we have already paid, my lord. Now, under both, on that enhanced amount, my lord, what the petitioners
And
are
that
claiming,
is what has
they are
been
paying
categorically
two
mentioned
interest,
in
my lord.
good pitch.
Pardon, Your Worship?
That is the law which has been categorically expressed in good pitching. Absolutely clearly it has been given. How much addition?
Sure,
But
sure.
I'm not getting here.
Your
You have the
Worship, we are,
internet out here in your miserable.
Your Worship, we are claiming only interest under section 28 on the enhanced amount.
That's all.
That is only what we're claiming.
You will be only entitled to that, only on the enhanced amount.
Yes.
That's all.
That, and Your Worship, in the writ petition, in the writ petition 68 of 2023, they themselves have stated that we are entitled to interest under section 28.
You are only on the enhancer.
Yes, that is what we, and that is what in their writ petition, that is the stand taken by them, that we are entitled to interest under section 28. But then now in the writ appeal, they are saying that no, you are entitled to interest under section 34 and not 28. They are contradicting themselves.
34 is a closed chapter.
Yes, Your Worship.
Because you have already received against the original amount.
So that is why if your lordship will see the pleadings submitted by the
Not
appellants,
necessary. That
they are
judgment
contradicting each other.
Judgment in Gurpreet Singh is there. We'll have it on Monday.
Yes.
Get that judgment on Monday. We'll put that. We'll dispose it on.
And we are claiming only 28 interest,
Mr.
nothing
Gupta,
else.
we are disposing it on Monday as per
My
that
lord, my lord.
paragraph of Gurpreet Singh. As
Yes,
I
my
told you
lord.
now that where Gurpreet Singh was not dealing with 28A. Gurpreet Singh
Yes.
was dealing with specifically with a reference code enhancement, then an enhancement by the High Court, then an enhancement
Yes.
by the Supreme Court. How much is the interest? Exactly that is what will be applicable here.
Yes. Yes, my lord.
So we'll dispose it on Monday. Okay?
Yes, Your Worship.
And
Okay.
get photocopies of this. Here the internet is bad.
Gurpreet Singh. Yes, Your
My lord, judgments have already given, my lord. It must be in the file.
Judgment has
my lord.
given. You are not here. Your judgment is not here. No, nothing is here.
My lord. My lord, may I pray on Tuesday, my lord? Tuesday.
Why? Tuesday, why? What is that good day about Tuesday? You become
I have to
religious
travel.
nowadays. Let's have it on Monday. Monday is also a good day. Come on Sunday. We'll have it on Monday.
My lord.
This is the matter again on Monday. And matter having been substantially heard. This is the matter again on Monday. Finally disposed. can attend the colleague's marriage of the, we will try to finish off as soon as possible. Yes, Mr. Counsel, what is wrong with the
My lord,
order?
regarding this particular accused, Sandeep sir, my lord, I received a verbal instruction saying that he now recently been, yesterday,
Yes.
discharged in the supplementary charge sheet. But for that, my lord, I have no written instruction. And if my learned PP, my lord, can obtain instruction for that, to clarify.
Your
You've
Worship,
been-
I have instructions
Discharge,
to,
my lord.
I have instructions to appear on behalf of the respondent number 2, Your Worship. And yesterday, a supplementary charge sheet was filed by the prosecution, by the case IO.
The state.
And in that, he has been,
Discharged.
the case IO has requested the CGM to discharge him. And he has not been included in the charge sheet.
Sandeep Sharma?
Yes, Your Worship. So,
So then you have to, then this petition has become infractuous.
infractions, yeah.
So yes, for that, my
So
lord,
under, he has been, then you have to file a protest petition before the trial court.
That is
Yes, my
if they so desire.
yes, my lord.
Because then it will be then converted, you may go for a further investigation or whatever may be, that might be taken.
My lord, exactly. And for that, my lord, since now it's only verbal, my lord, if
No,
My lord, I've just talked to the IO, case IO. It seems he's discharged.
They prayed for discharge.
what does the IO say? He has submitted the charge sheet?
Yes, my lord.
Supplementary charge.
Supplementary charge sheet. But he has taken it back so that he can make some corrections. But he has informed me that they will discharge this present petitioner.
So the
Respondent.
respondent number 2 is not implicated in the charge sheet.
Yes, my lord. That is the information I've received just now.
You have the charge sheet?
No, my lord, I don't have.
It was filed yesterday, Your Worship.
Before?
The CJ.
CJM.
So why are so many cases? Is it in one case?
Yes, yeah.
What about the others?
In one case, meaning 2 FIRs were lodged. One before the Aizawl police station, subsequently another FIR before the C and Economic Offence police station. But it relates to the same matter. And so the present respondents, they had been granted bail in both the cases by the lower courts. And
In
now,
all these cases?
yes, all these cases.
Yes. Then
And now the complainant has come up for cancellation in all these cases. But
in
except
all
for
these cases, the
except for
others have
7
been
and 8.
charge sheeted.
In all these cases, charge sheet has been filed.
Now, in all these cases,
Yes.
the other people who are there in the list,
Yes.
have they been charge sheeted?
Yes, Your
my
Worship.
lord,
Huh?
Yes.
Charge sheet.
Except for item 1 and item 5. Sandeep Sharma. Sandeep Sharma.
They have been charge sheeted.
Yes, except for item 1 and item 5. Sandeep Sharma.
Okay, and now tell me, Mr. Counsel, you are appearing for all.
my lord.
Why are you filing the applications for cancellation of bail?
Actually, my lord, as I have been submitted in the pleadings, my lord, that the learned court below mine failed to appreciate the seriousness of the case, inasmuch as have not also gone through all the case diaries, and also kindly bear with me, Lord. I will go through in respect of item number 2, my lord. The accused person who now is released on bail was Paul Zotan Puya. He's the proprietor of National Business Enterprise, a dealer of car company.
Dealer of?
Dealer of Tata car outlet here in Aizawl. So actually, Lordship, my ground herein as I have averred herein in my pleadings, my lord, is that the court below commit error in the eye of law, completely ignoring the case diary of instant case. It is worth to mention that diary was not produced. And that is number one. Number two, the role of the private respondent number two, my lord, has not been duly appreciated at the time when bail hearing was conducted, my lord. And number three, custodial interrogation of the accused, my lord, was not done.
Was not
Was not done
in any of the cases.
in this particular case. Yes, madam.
Which was Sandeep Sharma?
No. Sandeep
Sandeep Sharma was arrested.
Sharma is discharged now, madam. No issue. And now this is Paul, Mr. Paul Zotan. And in respect of Idol PS case number 96, my lord, he was also discharge sheeted. And even as initially he was released on bail by CJM, the court, the session judge, my lord, reversed the judgment and remanded back the matter for consideration. And in that time, in the meanwhile, my lord, the learned CJM released him for police remand for interrogation for 5 days, if I'm not mistaken, 3 days. And during that time also, my lord, he admitted himself in the hospital, my lord. So the police personnel do not have any chance of taking him into custody for interrogation, my lord. And on the time when that time given for police remand lapsed, my lord.
Let us see the FIR. Where is the FIR?
Page number, you watch,
What?
38.
In which case?
item number 2, lord.
Item number 2.
Number 2, my 38, my lord, Annex 1. And
FIR is Annexure 2.
Page 41.
41 is the complaint, my lord.
FIR.
Yes.
Type level.
If I may read, lordship, it is, we, Mahindra & Mahindra Financial Services Limited, are a company incorporated in the so-and-so and registered as non-banking financial company. And below there, my lord, paragraph number 1, companies engaged in internally in the business of financing loans so-and-so for the purpose of loans for vehicles. Number 2, here is in the paragraph number 2, lords. During our routine verification, we asked our area business manager, Mr. Zakir Habibur Hussain, who had sanctioned below mentioned loan, which were processed through his subordinate, Mr. Joseph V.L. Choi Moya, Valal Thana, Ralte, mobile number, and Mr. Eden Thara, to submit the extract of registration certificate of vehicles in question. But to our surprise, all PDF copies provided by Zakir Habibul Hussain shows same QR code with different number. Certificates submitted by Zakir Hussain appear to be fake. Further, we suspect that our employees colluding with dealers of car dealership and his representatives, the borrowers and guarantors, as well as some unknown accused, have cheated our organization. Due to these actions, the company does not have any security hypothecated vehicles under these contracts. People have misrepresented with the help of forged RTO records to avail loan from Mahindra Finance. The amount financed by Mahindra Finance in these 9
Now,
cases.
were these persons employees of yours?
No, my lord.
Huh?
They are not my employee, lord.
Employees of whom?
They are the proprietor of car dealers. And now in collusion with our employee, Zakir Hussain, my lord, they avail fake loan. Fake loan in the sense that they forge documents and signatures to form some fictitious persons to apply for loan. And once they applied for and obtained that loan, my lord, that loan goes into their account without actually buying cars and vehicles. My lord. So all this kind of racket, my lord, goes on to show that the total, my lord, the total fund involved is 150 crores altogether, my lord. Maybe more than that. Now that will be unearthed by further.
So how much amount has been do you estimate the company has lost?
Actually, that now, my lord, the total scam involved is 150 crores,
150 crores.
my lord.
But in your FIR, you have said it.
Yes, my lord, there are different cases against different persons, my lord. And each persons involve certain amounts. And
No, all these, how many employees were there? Only one. Zakir Hussain.
no, my lord, Zakir and his subordinates are also involved, my lord. Altogether, if I'm not mistaken, my lord, there are tens of, I think, I'm not sure about that. Persons involved in there who also are under our establishment, my lord.
50 crores. 50 crores. I don't know.
And in all these cases, there is these two FIRs.
Three, my lord, altogether. The first one,
How
the first
many
one,
FIRs are there? Because there cannot be more FIRs than one.
Yes, sir.
That is the law. There
But-
can be only one
Yeah.
FIR and it can be
but
subsequently,
on,
you can submit. That is, isn't that the law?
Judge, the third FIR which my learned friend is talking about is submitted by a third person, not by Mahindra. Mahindra have filed two FIRs on the same cause of action.
yes, but relating to the same scam, my lord.
So that is why two FIRs are not
No, there cannot
yeah,
be two FIRs. There can be
sustainable.
only one FIR.
Actually, my lord, the first FIR was regarding this scam, and the second that my learned friend has referred to is regarding forgery, my lord. It's a different issue, my lord. And the manner of investigation to be conducted is also different. So actually, it's not on the same issue, my lord.
My lords, if I may just interject.
Who is the petitioner number 2 in this item number 2?
Mahindra, my lord,
Paul
before he lost.
POA, holder of the proprietor of National Business Aizol, Katla. So this is the same FIR, and let's see what is the order passed.
The impugned order, lordship, is at page 59.
Now, where is the initial order? Anticipatory bail applications were rejected.
Yes,
Then
successive
what are you
petitions,
challenging here?
59, my lord.
In
Page-
item number 2?
Item number 259, page 59. After earlier applications were rejected, successive applications were filed, my lord. And this ultimately is the one which grant anticipatory bail, my lord. 59. Anticipatory bail application number 28 of 24.
This is the impugned order, page 59.
Yes,
My
sir.
lord.
This is the anticipatory bail granted in the crime and economic offense case number 3 of 2024.
So this person in item number 2 was granted an anticipatory bail.
My lord.
That is why you have come for cancellation.
My lord, exactly. While anticipatory bail applied for similarly situated persons, my lord, have also been rejected, which I have enclosed a copy of the rejection order, my lord.
And what is page 62?
62, Lordship. Yes, dismissal order of earlier petition filed,
Different persons, yeah.
different persons,
Different accused.
Samsielo and Ruzia
I
Sarma.
don't know whether these have any relevance, Your Worship.
To show that, my lord, persons who are similarly involved were not granted bail.
4th of April, anticipatory bail application of another person, of whom?
Co-accused, Your Worship.
Co-accused, my lord, in the
Huh?
same scam, my lord.
Page 62 is whose?
Page
Page
62 is bail application submitted by two persons, Your Worship.
That
Anticipatory.
was rejected.
That was rejected.
And page 59 is an anticipatory bail application. Now, what you are asking out here in this 27.5, that is this order.
Page 59. Your Worship, subsequent to this, even the co-accused at page 62,
Page 60, it is reasonable to expect that the investigation will not be hampered if the police has opportunity for custodial interrogation of the petitioner accused in relation to the instant case for his arrest in the case filed on 23. Was he arrested?
yes, Your Worship.
Yes, your lordship.
The petition number, respond number 2.
Yes. In
This
the,
person,
in the first
Paul,
FIR.
Paul J. John,
Yes.
he was arrested
Yes.
and he was granted bail in some other case.
Yes.
Yes.
Two FIRs, Your Worship. If I may take Your Lordship to page 59.
And this order of 23 2000, and where did he get this bail? This order, he must have got bail, a
Yes.
regular bail in some other application.
Yes.
Yes.
Where? In which case?
That is in serial number 4.
Give me 4. Now this order is being also challenged. Which order is this? Item number 4,
Page 37.
57.
Page 37.
Yes, your lordship.
Page 32.
37, your lordship. Annex
This is
2.
Madhurya Borua. Madhurya Sharma. Page
Page 37, Your Worship.
37.
Yes.
37, item number, yeah,
4.
item
Annexure
number
2.
4 is, what is the number? Criminal
17.
petition 17.
Yes, Your Worship.
Yes.
This is an affidavit, okay. Page 7. This is of 7th of June.
Yes, Your Worship. Your Worship, in this order, the prayer for remand and the bail applications were considered together at one go. The reasoning of the Honorable Court starts from page 47, para 11.
Kindly come to page 51.
Yes, Your Honor.
Paragraph 18. Nevertheless, this court has come to the conclusion that the mandatory provisions of the section 167(2)(b).
Yes.
So he has been granted the bail on the ground of 167(2)(b).
Yes, Your Honor.
Is it?
Yes. The reasoning starts from paragraph 11, but subsequently para 18, he was not produced.
Now, has he violated any of these conditions? He was inside, this fellow, this Mr. John.
He was arrested, Your Worship,
He,
and subsequently he was admitted in the hospital.
Then,
And as on date, there is no allegation of violation of any of the bail conditions.
then why should we?
And charge sheet has already been filed in July. And in both the cases, Your Worship, charge sheet was filed in July and August. Till today, the trial has not been initiated, started. Although charge sheet was filed in both the FIRs in July and August. And yesterday, a supplementary charge sheet was filed in the first FIR.
We have it on next Monday. Use the charge sheets. Okay. All these matters are same.
Yeah.
Item number 1 to 7, na?
1 to 8, Lordship.
1 to 8. This matters again on Monday. On which state? The learned state, learned PP. You have PP?
Yes, my lord.
Shall produce the charge sheet. So the charge sheet as well as the supplementary charge sheets which have been filed in connection with the subject matter of the present petition, revision petitions.
There are two charge sheets, Lordship. One in economic,
Okay, whatever may be.
all the charge sheets.
One is against an anticipatory bail. The anticipatory bail has been given because in connection with the same, he was under police custody. The 167(2)(b), this was being done. What is the perversity? Have a look at the judgment, Mr. Counsel.
My lord.
Azwar versus Wasim, 2024 INSC 438. It is a judgment of the Supreme Court, the Supreme Court
Sorry, Lordship.
of Justice Hima Kohli and Justice A. Amanullah, dated 17th of May 2024. Okay. I'll take another copy. You have a look at it. More particularly, see from paragraph 26 and for your case from 28 onwards. Have a look at it. We'll have it on Monday. And there is one more matter.
Yes.
7, 8,
9 and 10, why these are the matters that come?
9.
Just take it.
Why not in 10?
Yes, item number 9, you are there?
Item number 9.
9, my lord, we have received paper book. It can be fixed for hearing.
Paper book made.
Yes, my lord, we have received.
And everybody is represented.
Yes, my lord, it's under 376.
Huh?
376.
Everybody is appearing.
Yes, my lord.
Okay.
And
Taking
because is
into
here.
account that the pursuant to the order passed by this court, dated 2/8/2024, the paper book has been prepared and all the parties are duly represented, list this matter for hearing. When? One is inside.
My lords, in the usual course, it may be listed in the usual course, my lords.
Is he inside?
Yes, my lord.
Yes, my lords, that's correct.
So we'll have it on a date on 18th of November.
All right.
18th of November. Because it's a person's liberty is which.
No, my lords.
Item number 10.
Obliged.
Obliged.
Please, Your Lordship, my lord, in item number 10, the service on respondent number 2 is complete, and I believe that the acknowledgement receipt is submitted to the court master, my lord.
Now, the respondent number, is the paper book made? Paper book, no.
My lord, we have already received a paper book. It's ready for hearing, but then in the meantime, due to the Deepak Nayar's case, the respondent number 2 was in notice was served again.
No, you
And
have
if Your
already-
Lordship deem fit and
No,
proper, then
you have already effected service upon respondent number 2. So if there's nobody out there, we ask somebody to appear on behalf of respondent number 2. We'll appoint
yes,
an
my lord,
amicus.
if Your Lordship deem fit and proper, then amicus may be appointed for respondent number 2.
I think for respondent number 2, an amicus requires to be appointed. Yes. Who is willing to become an amicus for respondent number 2, do some social service? And you are appearing for the appellant.
Yes, my lord. I am appearing on behalf of my senior.
You are appearing for the appellant.
Yes, my lord.
And madam, you are appearing for the respondent number 1
For the state respondent, yes.
for the state. Paper book, who is going to bring? Does it is not
Paper
here.
book is already
It
it's
is not
already
here
listed.
mention anything. The record does not show as to whether the paper book have been prepared or not. Full stop. This court have also taken note of that in pursuance to the directions passed by this court on 17/9/2024, the service was effected upon the respondent number 2. Full stop. However, the respondent number 2 is not represented. Full stop. Taking into account that this matter pertains to a case coming within the ambit of Section 6 of the POSCO Act of 2012, this court, for the interest of justice, appoints whom?
My lord, I think she can be appointed.
You're there? You have a list of amicus curiae here? No.
Legal aid list. The legal aid council's list.
Yes, Mr. A.R. Malhotra, I think you should be. Do something. You have been doing many other matters. Who is there? Appoint so-and-so as the amicus curiae to represent the respondent number 2. Full stop. The registry on preparation of the paper book shall furnish copies of the paper book to all the parties, including Mr. So-and-so, who have been appointed as the amicus by this court today. Full stop. The registry shall show also the name of Mr. So-and-so in the cause list appearing on behalf of the respondent number 2. Full stop. List this matter again on 11th of November 2024 in the orders column. Wait, I have it for hearing? Oh no, orders, for orders.
Like,